This was rough. I mean, seriously rough. It was just unbelievable to listen to. As you know, she has struggled in the past in some various capacity, but this one, I don't understand the argument. It makes no sense, and it sounds completely incoherent. So we're going to hop right into it, but before we do that, if you are new here, please do subscribe. It's free if you don't like the channel. Later, you can always unsubscribe, but I really appreciate it. So yeah, let's hop into it. So basically, Louisiana was redrawing after the 2020 census their congressional map, and they drew it in such a way that there was only one majority black district. Now, a group of black voters sued the state of Louisiana over this, claiming that they needed more than that because it kind of was silencing black voices, in their words. And so they redrew it and they had 2 black districts. Now another group of voters, of non-black voters in this case, is suing the state of Louisiana, saying that that's racist and that the Voting Rights Act violates the 15th Amendment. And there are a lot of things we can say about this from a legal perspective, but I'll leave that to Mark Smith over at the Four Boxes Diner. But I think let's just to deal with the case part first. I mean, a lot of this is going to be about Ketanji, but just to deal with the case part first. Thinking about this logically, it's kind of insane. So they sued because they said you drew the map. So Louisiana's about a third black, right? So they said you drew the map, so there's only one black voting district, and that's racist. The thing is that presupposes that you're looking for like black majority district, black majority district, black majority district, and then 6 white ones. That's insane. That's insane. Voting is not a racialized thing. There certainly are trends and racial preferences, but as we've seen in 2020 and 2024, that's changing. For a while, you would have said like Hispanics see their own voting districts separate from whites, right? But now do we group them together because they're both predominantly Republican voting groups? No, it's ridiculous. And the idea, and by the way, Donald Trump in 2024 won the biggest share of the black vote that any Republican has. But that's not really the point. Like, gerrymandering is actually a problem on political grounds, right? Because you can draw the district such that, let's say, you have a tiny majority in all of them, and you have a big, unfavorable majority in the other. And that causes a lot of problems. So we do want to draw the electoral maps fairly. The problem is, race isn't really relevant in that. Because you have 2 options, right? You have a Republican and a Democrat. And so you'd think the only thing that matters is like who wins out of those 2. So like, why is race even a factor in any of this to begin with? It's completely weird, completely insane. But Ketanji Brown Jackson doesn't think so. So we're gonna play you a couple clips. This is gonna be a tough watch. Okay, so just to preface this first clip we're gonna watch, it's been interesting. She compares black voters to disabled people. It's a verbal flub, to be sure, but I want you to think about the argument underlying what she has to say. So I'm gonna play this clip and then we're gonna talk about it.
I guess I'm thinking of the fact that remedial action, absent discriminatory intent, is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open.
So the first thing she did was compare it to the ADA. Now, the reason we have the ADA, the Americans with Disabilities Act, is because disabled people physically cannot walk to the post office unless you put a disabled parking spot there. It presents a huge undue burden, and it's not really a big deal. The reason you're sequestering them is you're saying, okay, this is a medical necessity, so we are giving them a medical necessity. But here's the thing, that comparison doesn't work with voting maps at all, like not even a little bit. Think about it logically. So obviously it is true that if you're saying like there's a black candidate and a white candidate, then no black candidates will win in any of the select districts if only a third of them and each one are black. But that's not how our electoral system works in any way, shape, or form, right? You have Democrat, Republican, and I hate to break it to you, about half of white people vote for Democrats. right? It's not like it's like 1990, and even if it was, it's a separate topic. But in each individual district, each person will have the same vote as anyone else. Politics isn't actually that racially segregated when you think about it. In many states, the majority of Hispanics will vote for in her mind frame, the white candidate, and many white people will vote for, in her mind, the black candidate. But here's the thing. There is no black candidate and there is no white candidate. There's a Democrat and there's a Republican and there's some other Green Party idiot that no one cares about and a Libertarian who I love, but is not going to win. So the psychology that underlies her is actually something you see in many institutions around the world, where they have to think of everything as a group as opposed to an individual. And that is not how our voting system works. That is not how our voting system works. And she's completely unable to articulate this. I'm going to play another clip. Obviously, that comparison with the ADA is just unbelievable, just insane. But I'm gonna play another clip from her. She gets really mad on this one and cuts him off. It's really something to see, and it really shows. I think to a large degree, she feels it should act this way, but it is not the way our voting system acts. And as a Supreme Court justice, your job really isn't to make laws work the way you feel that they work. And I guess this isn't my originalism speaking, but your job as a Supreme Court justice is to interpret the law. The law has been set by someone else other than you. You are not the one setting the law. You are interpreting it. Someone else has set the law in the case of the Second Amendment. And if I was an anti-gun judge and I read, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed, I'd go, okay, maybe I don't like guns. Maybe I'm anti-gunner. But in this instance, okay, well, I can read the text and I'm interpreting it, so I guess the right of the people to keep and bear arms shall not be infringed. And I would do that in many cases, in every case, that would go against myself as a judge. And I think that's one of the things that many of these left-wing judges can't get their mind around. I'm not saying right-wing judges can't do it too, or original justices don't occasionally make mistakes. But it is so telling that she can't get her mind around this. So I'm going to play this next clip. This one, she gets heated. It's pretty crazy. I'll play it now.
Jackson. Wait, so can I just ask, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA, states can remedy intentional
No, I'm not talking about the remedy. I'm talking about
identify.
Identify.
Of course.
All right. So if I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's not,
black
because again, just trust me on this. The second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many Section 2 cases, the court says, you're wrong. You're fine. There is not an electoral opportunity being denied to you. Go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right. And the problem, Justice Jackson, that the Middle District identified was not intentional discrimination. And in fact, I think
Why
when I
do
hear
you need intentional discrimination to remedy a problem like the one that I've identified?
Because if you're going to use race the way that the Robinson appellants want the court to use race in drawing a second majority-minority district, you've got to have a compelling interest.
Thank you.
And Thank you, Mr. Chief Justice.
Thank you, counsel. Mr. Grime?
I'm not even going to touch on her conduct. You can touch on that if you like in the comments down below. But I think, again, what we need to look at here is just the psychology that underlies the point she's making. The idea that there is an electoral opportunity being denied to you because you're a member of a minority group in any jurisdiction is wild. No, of course not. If you're a Republican, you're voting Republican. If you're a black dude, you vote Republican. You're voting Republican. If you're a black dude, you're voting Democrat. You're voting Democrat. And that is what we're doing here. right? That is just simply what we're doing here. There is not a black candidate. There is not a white candidate. There's just a candidate that has an R or D next to their name, and maybe sometimes they have a G or an L or an I, and if they're one of those three, unless you're in Vermont, you're not going to get elected. And that's how our voting system works. It's all about individuals. It's all about individuals, not about collectives. And that's what you see with these left-wing judges. Everything to them is collective. Everything to them is collective. There's good in groups, there's bad in groups. There's groups and there's groups of people that have committed crimes, and they have large scale socioeconomic factors. And this is why you see that, by the way. This is why you see that. You go, okay, well, this group has a 42% lower chance of receiving this degree of education, and that's how we can explain this crime. That is true on a population level. That is true on a population level. You can make predictive guesses based on various factors, and that will lead to various outcomes. But the reason someone steals a car is not just because they had a 42% lower chance of, let's say, graduating high school. Does that play into it? Sure. But on a population level, sure. The individual has made choices that lead to an outcome. The individual has made a series, almost an uncountable series of choices that have led to an outcome. It is not we are not a collective system of rights. We are a government in a country, quite uniquely, governed by a series of individual rights afforded to you, and one of them is voting. That is an individual right. It is not a collective right. It is not black people voting. It's not white people voting. It's me voting. It's you voting. And you get the same vote as everyone else. It's an unbelievable argument. I really don't understand this. I'd really like if someone underline this in the comments down below, because I don't get it. If you're on the other side of this, please do explain. This really, really doesn't make sense to me on almost any level, politically, legally, or otherwise. I don't understand how this is considered disenfranchisement. But maybe I'm stupid. Maybe I don't understand. But I've really tried to, and it really doesn't make sense to me. The argument has not been presented as she argues, that this represents some sort of grand breach of disenfranchisement. Really doesn't read that way to me. But anyway, what do I know? So anyway, if you did enjoy the video, though, please do leave a subscribe down below and a like. I'd really appreciate that. If you have any comments, please do leave them down below. If you disagree with me, by the way, please feel free to comment. I love to read it. Anyway, hope you did enjoy, and I'll see you in the next one.